Ms. Store, Bennett Store. Doctor? Oh, Mr. How you doing? Good. Oh, okay. Either. No, you're good. You're gonna be second case. Thanks. Kevin. The second case and third case is here. No way it's going to This is yeah. Ms. Store?
Yes.
Oh, hey. Morning, how you doing?
Wait.
I'm Kevin.
Yes.
Did I meet you already? I'm Devin.
I know I need Josh.
John, maybe that's what you're kind of, you know. Okay, Kevin. All rise. All persons having business before the Honorable Chief Judge and some Chief Judges that reside over the District of Columbia Court of Appeals. Go there and give your attention. God save the United States in this honorable court. This honorable court is now in session. Please be seated and come to order.
Good morning and welcome to the District of Columbia Court of Appeals. And counsel, you can be seated. We have 3 cases before the court this morning. I am joined this morning by Associate Judge Ali Khan to my right and Senior Judge Glickman to my left. Our first case this morning is Catherine Leach versus One Parking 555 LLC. And counsel, are you ready to proceed?
Yes, I am, Your Honor.
Thank you.
May it please the court. My name is Kevin Leach. I represent the plaintiff, Mrs. Catherine Leach. Chief Judge Blackburn Rigsby, I would like to reserve 2 minutes for rebuttal at this time.
Great, thank you.
Your Honors, this is a trip and fall case. We're asking for reversal of summary judgment granted to the defendant. The only question for the court is whether there are issues of material fact showing the defendant had constructive notice of a dangerous condition. Facts are brief. Mrs. Leach and her husband drove to DC to meet their daughter Abigail for a movie on.
Also, may I interrupt, because I think you're right that the issue or the key issue I see is whether there was constructive notice here, and that's a question of fact.
Yes, Your Honor.
In large part. What facts do we have?
We have 3 levels of facts.
That there was constructive notice that this was a hazard.
I appreciate that, Judge. There are 3 levels of facts, and I'll address your question this way. The first level of facts is the facts of the fall, indicating that there was an optical illusion for Mrs. Leach as she was walking.
Well, there's the fact of the fall.
Yes, there is the fact.
I don't know that's a fact indicating that there was an optical illusion, but maybe there's other support for that.
Yes, indeed, Your Honor. There's the other facts would be the expert facts as well. There are 2 forensic experts that were used in this case, and they had opinions presented to the judge. They were completely ignored.
Do those opinions from the experts constitute an establishment that there was a standard of care here that was violated?
Yes, Your Honor. The experts opine that the DC code has requirements to keep the walkways maintained free from hazardous conditions and to have unobstructed paths of travel from anywhere inside a building to the exit.
And see, typically when we think of constructive notice about a hazard, we have a lot of cases, for example, where there's a huge pothole that has caused damage to a number of cars or caused people to trip, and has been in existence in a visible area for a long time, where we say it was sufficient that the District of Columbia should have known.
Correct.
That this hazardous pothole caused people to trip or fall or cars to be damaged. Here, the step appears from the photos to be in good condition. It doesn't seem to be crumbled or cracked or anything. What is it about it that leads to your intention that there was notice that something was wrong with the step that the parking garage should have known about?
So, Your Honor, remember that the facts in this case, I can do it in two ways. Number one, you have a photograph, even without an expert, you have the photograph of Mr. Shinsky's forensic report at page 56 of the appendix. Shows two different markings on these almost exactly the same type of risers. One is marked according to the safety standards, industry standards with hash marks on the top. That's an obvious change to the markings that are below. So
those are photos 3, 4, and or 5. And
these are photos 1 and 2, page 7 of Mr. Ferenczi's report for Robson Forensic. Mm-hmm. So yes, indeed, there is an obvious change to the differences on these two risers. Why is that? Well, they were never corrected because this defendant, remember, the defendant did not have any qualified person on its staff. They did not hire anybody, even though under the contract, they were responsible for the maintenance and safety of the garage. That was an issue already decided by the trial court. That was not something that we have to discuss here. So once the judge has determined it's your duty to make sure your premises are safe, you have to hire somebody qualified to notice this. Now, if you were looking
at to hire somebody, now where does that come from?
So I am interpreting the fact that if you are in a contract and it's your responsibility to maintain the premises, then you are required, any business is required, to have the qualified personnel.
So I take that point, but didn't the trial court find that there was no dangerous condition?
They said there was no dangerous condition. There are no facts of a dangerous condition. But remember, the facts are for the jury to decide. Are there facts? And there, as I said, we have 3 levels of facts here. Number one, it's a dangerous condition because what is an optical illusion? Optical illusion is painted in a way that would be a hidden latent defect. Well, it's not latent to any expert who goes in there and takes a look at this. They see it in a minute. They see that this is different and it's wrong. But if the defendant does not have the qualifications to determine that there is a hazard on these 2 different stairways or these 2 different steps, then
but
they're
it seems
liable.
Like you're getting ahead of yourself. I mean, I think first we have to establish that the question of whether it's a dangerous condition is one that needs to go to a jury, and then all of this evidence comes in.
I appreciate that, Judge. I'll try to direct my answer to that. The facts are that the jury gets to determine under the circumstances of this case. You have a normal person, invitee, female invitee, walking towards this stairway. She has her hands in her pockets. She's not distracted. She's not talking. She's not looking around, not carrying anything. She walks across the yellow lines and her foot strikes the riser, which is painted the same width as the yellow lines in the parking area. From her angle, a jury can determine, based on these circumstances, from her angle, her height, her lighting, that when she walks and hits this riser, falls over, hands still in the pockets, she's acting as though she doesn't see this. It's an optical illusion. It looks like a flat surface.
I don't mean to interrupt you, but I did want to note, and I apologize for not mentioning this earlier, that counsel, if you choose, are free to remove your mask.
Thank you.
While you're speaking at the podium.
Thank you so much, Judge. It's
earlier.
difficult to speak.
Yes.
Thank you so much. Appreciate that. So yes, absolutely. So when she is walking in this fashion with this lighting, these factors, a jury should decide whether she's acting in a way that this is an optical illusion. There's no other reasonable explanation.
Right. A jury should decide, but we still have to get to this constructive notice issue a little bit.
Certainly.
And one of the elements of constructive notice is whether there is a hazard. And then the other element, as I understand it, is whether it existed for a period of time sufficient so that the person liable for the hazard, alleged hazard, has noticed or should have known that it was a hazard.
And so the record, Your Honor, says the defendant had 17 months, over a year, to detect the dangerous condition. But One Parking didn't hire a qualified employee to assess safety risks due to budget constraints. That is part of their testimony, even though it was their job to do that.
In determining whether there was a dangerous condition here, is it relevant that the staircase had been in use for 17 months and no one had reported that there was any problem? No one had been injured. people had just used it like a normal staircase. Is that relevant?
I don't believe that is relevant, Judge.
Why is that?
It is
not relevant?
always a dangerous condition if it does not conform to safety standards.
Well, if it's a dangerous condition, then it's a dangerous condition. But if we're trying to ask ourselves, was it in fact a dangerous condition? It would seem as if the proof might be in the pudding. And the fact that for 17 months, people walked on it daily and its condition did not change on the particular occasion we have here, one might think that that's strong evidence that it's not a dangerous condition and that what happened here, people do fall and they often fall for reasons that have nothing to do with dangerous conditions.
I respectfully would disagree only to the extent that I believe statistics like this are frequently not allowed because they're hearsay evidence. They don't advance the probative value of what we have before us. Somebody can say, well, there are no accidents. Doesn't mean no one tripped. No one reported an accident. I know that, but it doesn't mean it was a safe condition. It doesn't mean that it
well, it
didn't
goes to the question of whether the owners of the property or the people who are operating it have noticed that there's a dangerous condition here.
I would only suggest, Judge, I think it's a bad rule to use in this court because whether they notice it or not, we want a rule that says when you are maintaining property that does not conform to the safety standards and it's different than the other safety standards you use on your property, just because nobody has fallen yet, I don't think that's the rule to follow. Nobody fell yet.
So I take that point, but what is the standard of care? I know you keep kind of contrasting between what this landing looked like on another floor, but don't you have to establish a standard of care?
The standard of care is that a property owner has to use reasonable care to make sure that its premises are safe for expectable users, invitees such as this. Reasonable care. What is reasonable care under these circumstances? Reasonable care at a minimum means you have to have a qualified person inspect your premises to determine if there are any issues. This is one of the biggest cities in the world. You're using your premises for government workers, diplomats, teachers, everybody from all over comes to this city.
Well, but I thought your contention was that reasonable care under these circumstances are what the two experts opined about, that the markings had to be in a certain way, that railings were needed to demarcate the single step riser from the pavement below to give warning and to have signs. And
right.
Part of what I understand appellant's argument to be is that that's what they did. They had yellow stripes. They just weren't in the same design pattern that's suggested or recommended or opined by the experts. What do we make of that?
That to me, Judge, as should everybody on this court should be saying, if there's a dispute as to who's right, that's reasonable care. That's a jury question. That's a jury question for them to decide. Did the owner use reasonable care under the facts and circumstances of this case? Case closed.
What do we make of the trial judge's finding, determination? I'm not sure what we should call it. His determination from looking at one of the photos that there was no hazard here.
If the judge looks at it, he's weighing the evidence. And I will suggest to the court that there are many cases right now, even the federal court, Fourth Circuit, very conservative. They are making pronouncements, do not weigh the evidence. Do not weigh the evidence as the judge, as a trial court. The trial court is only supposed to determine, are there issues of fact for a jury to decide? Not whether the judge would decide it one way or they've decided another way.
But I suppose it's not whether he's weighing the evidence. The question is he determining that no reasonable juror could find that defective condition existed? Because I think you would agree that if the conclusion was that no reasonable juror could find this, then summary judgment would be appropriate.
Well, I would say that the way he phrased it also, he's looking at a photograph and he's saying this does not depict the dangerous condition at all. But that to me, I think anybody looking at this is he's doing the exact same thing a juror would be doing. He's doing what the jury should be doing under these circumstances. It's a unique case where somebody is falling over a riser, but it's not painted in the same way as another riser is. Why is the difference in the same building, one floor up, that has the actual safety markings the experts are calling for? I think that he's not actually evaluating all the evidence.
Thank you. Did you want to reserve the remaining 2 minutes?
Yes, Your Honor, if I could. Thank you so much.
And I may take off my mask?
Yes.
Okay, thank you. Good morning, Your Honors. May it please the court. My name is Ellen Stewart, and I represent the Appellee One Parking 555 LLC. Your Honors brought out some very clear points of the trial court looked at what little evidence there is, the photographs, the testimony of Mr. Leshner and the reports, and said, there's no hazard here. No reasonable jury could find that there's a hazard. Looking at what the experts say, they suggest ways for how this step should be made conspicuous.
Well, that was one of the trial judge's findings that troubled me a little bit, because I read the two expert reports as saying, this is a hazard. This is not the way that you delineate a single step riser, and that's what caused the fall. I don't see them as saying, well, you know, perhaps they should have done this, perhaps they should have done that. They say that it was not correctly marked under national and other standards. And that, having two separate experts say that and no expert from the appellant contradicted, it seems to me that the trial judge's pronouncement may not have been consistent with what's in the experts' reports.
And Your Honor, that's a great question. And the issue here is you look at what the actual evidence is. The experts' ipsy-dixit opinions are not evidence. That's not admissible evidence that would defeat summary judgment. The facts.
Why isn't it? I mean, a lot of times in these tort cases, we are asking, we're saying that expert testimony is needed if an issue is beyond the ken of a juror. Here we have testimony from two experts for the plaintiff and no expert from the appellant. I'm sorry, the appellants and the appellees. No expert, and all we have is the appellees saying, well, we did have markings. And then we have two experts from the appellant saying they're not done correctly and consistent with the standard practice. And so to me, either that seems like a clear question of fact that should go to a jury.
And Your Honor, the reason it's not a question of fact is because the facts are, both experts say, there's no specific way, there's no codified requirement as to how these should be marked. The ways to make a stair conspicuous are to have contrasting colors like this stair did, to have handrails like this stair did. So the opinions of the experts of just, it's dangerous because I say it is, that's not admissible evidence. The admissible evidence is you have the gap between the cross hatching before you get to the stair, you have handrails on either side, and you have those contrasting colors such that it's very clear there's a change in elevation, because you have all these things that the experts themselves said, these are the ways to make a stair conspicuous. And just because they say it's dangerous because I say it is, that's not admissible evidence.
They're saying it's dangerous because the markings were not correctly done, essentially. And that seems to contrast with the appellee's contention that, well, we did have markings, we did have railings. And so then that to me is what puts it in the purview of the jury. Are these appropriate? Are these consistent? Are these markings that will prevent a hazard? Let me ask you about the notice issue.
Yes.
Why would you contend that the parking garage here did not have adequate notice?
And Your Honor, I think that would best be answered by what Judge Glickman asked counsel earlier, is you have 17 months of people using the stair and no one's tripping, no one's reporting any injuries. And that's because it's an open and obvious condition that there's a stair here. There's nothing hidden about it. In fact, it's marked so that you can see that it's a stair. And so because you have all these people who are using this stair, that's relevant to the question of constructive notice. Because
does somebody have to be injured before there's notice? I mean, don't we want to prevent injuries by addressing a hazardous condition before somebody's injured?
Oh, absolutely, we want to prevent them, but the key there is there has to be a hazardous condition. And here there's not. There's no evidence that there's a hazardous condition. And because there's no evidence of a hazardous condition, you have no constructive notice. Again, the question of,
I guess it's circular in some ways, because there is evidence that there's a hazardous condition, arguably. And then if there is, then who's supposed to determine as a threshold matter? The judge here or a jury?
And here, this is a question for the judge, because again, there's no evidence upon which a reasonable jury could find that there's a hazard or find that there's constructive notice. And again, I'm trying not to repeat myself too much, but the actual admissible evidence are the facts of, we have a open, obvious issue. We have the demarcation from here's a flat surface to here there's a stair. The ipsy-dixit unfounded opinions are not evidence.
Why are you saying that they're unfounded opinions? I mean, because you have an architect and an engineer who are looking at this and determining that the way the demarcations that are there are done create almost an optical illusion that make the surface appear to be a continuous plane. And they do give supported reasons in each of their respective reports for why, based on their training and expertise, they believe these markings that were there, perhaps well-intentioned markings, were not done correctly and created a hazard because of the way that they are done. And I understand that there may be disputes about their opinion, but that seems to be the essence of what you have a fact finder do at trial.
And Your Honor, it's their conclusory statements don't coincide with the actual facts. Mr. Shinsky, in his report at page 154 in the appendix, he says, the face of the riser was painted yellow. The walking surface of the landing was not painted. Facing the landing from the garage floor looking south, there's a triple rail guardrail along both sides of the landing. He's pointing out all these things that are used to show that there's a stair here. On 4 pages later in his report, page 158 of the appendix is where he lists suggested ways to accomplish making a stair conspicuous. And again, he says handrails along both sides of the stair. He already said we have those there. He says to refinish stair treads, surrounding surfaces in a manner that will accentuate the visibility of the treads. Again, we have different colors. The landing itself is not painted. The floor is a different color. The face is painted yellow. So we have all these things here that he's listing as ways to make it conspicuous. The same with Mr. Leshner. His deposition testimony, starting at page 120 in the appendix, he says the standards talk about you shall not be hazard and conspicuous, and there's guidance on how to paint the step, but no codified standard on exactly how to do that. The words that both experts keep saying is guidance as to how it's done. And Mr. Leshner on page 121 of the appendix says the same thing that Mr. Shinsky says. Handrails. Again, there are handrails on either side of the stair. And he says contrasting colors. And I think the best photo to look at is probably on page 157 of the appendix. I know there's various photographs included. That's from Mr. Shinsky's report. And that shows you there's clearly a stair there. There's no optical illusion. It's very open.
What about photograph 1?
Referring to Mr. Shinsky's photograph 1 or
taken by Mr. Leshner on May 30th, 2018. That's on page 157.
Yes. And Your Honor, that's where's the Dutch?
Are these 2 pictures of the same Because they look very different. I guess they're different dates.
They're different dates, but it's the same stair. It's just taken, one's a little closer up, or they're taken at different angles.
Right. No, but the markings are very different on in these two pictures. If it's the same stair.
You're referring to photograph 2. Is that correct?
Photograph 1 is the one taken by Michael Leschner
Yes.
on May 30th, 2018. And that's the one that as I look at it, and as other experts, one of the experts, Leschner, looked at it, seems to give you that optical illusion, and the markings there are very different from the photograph 2, where those markings are not present and it's a later date. I'm wondering if they were changed or repaired.
Your Honor, photograph 2 is taken from a different floor, and that's different because that landing is much smaller. The space of where somebody would step out from that door leaving the stairwell is much smaller, and that's why that step is different, because it has to distinguish.
Looking at the first picture, what are the yellow zebra stripe lines doing there? They don't seem to me to be related to the riser.
And that's contained in Mr. Shinsky's report. He has a diagram. It's a pedestrian walkway that goes throughout the garage. So pedestrians know where to go to get to the elevators.
And so why would it not be a jury question whether that yellow demarcation of the riser could be confused as part of the pedestrian walkway as opposed to a notification that there was a change in elevation?
And that goes back to, because there's no evidence that this is a hazard. As Your Honor started to ask counsel earlier, we don't know why this woman fell. She doesn't remember the incident. She doesn't remember. Nobody knows what she saw. She's walking and she fell. The mere happening of an accident is not negative.
One of the affidavits that she admitted says, in support of her case, says that she didn't see a step. She didn't know there was a step there. I think that's the quote. I didn't know there was a step there.
Correct, but that doesn't answer the question of where is she looking, what is she doing, what is she observing? And we don't know the answers to those, and putting that to the jury would cause them to speculate. All we know is she's walking, she fell.
Do I understand correctly that as a person walks toward that step, the person can see the following? On the path, stripe yellow lines directing the person in that direction. Then culminating in a line that cuts across, a yellow line of several inches in diameter that cuts across, that demarks the first riser, the first step. Is that right?
Correct.
And then one can see, the person looking at that can see two things: handrails on both sides and a dark colored floor above that yellow riser. Is that right?
That is all correct, Your Honor.
So all that is visible to the person who is looking where they're going.
Yes.
As they approach that staircase. And is it only a one step? As I understand,
A single
it's
stair.
only a single
Correct.
step. So, well, I mean, if the test is, there has to be something conspicuous showing, this is what it comes down to. There has to be something conspicuous showing of the casual walker that there's a step there. It sounds to me like this was conspicuous. It may not be, it may be that people can argue over, well, there are other ways to do it. And it may be that people can argue that there are better ways to do it. You could have big neon lights and you could have a big sign and you could do all sorts of things. But if the question is, was it, were the operators of this on notice that there was an inconspicuous step here? It's a little hard for me to see how they're on notice of that.
I agree with you, Your Honor. You know, there's any number of experts can have different opinions, but when you look at the facts and everything that you
I mean,
just listed.
it's not like
and-
there's a national standard that
Exactly.
says, am I correct about this? There's no national standard that says, well, you need a sign that says step here.
No, and both
And,
experts say the opposite of there is no
The
standard.
national standard is simply, there needs to be something conspicuous to alert people that there's
Exactly.
a step.
Exactly. And if your honors don't mind, I just want to point out one other thing is on page 167 of the appendix is another photograph. That's a close-up photograph from Mr. Leshner. And that shows that there is a distance between where the cross-hatching is and the stair. And he also talks about that in his deposition testimony at page 122 and says there's no standard requirement as to how much space there needs to be. Again, there's no codified standard. It's just here's some suggestions of how to make a stair conspicuous.
All right. Thank you,
Thank-
counsel.
Thank you.
All right, Mr. Leach.
So everything I heard on the argument from defense counsel sounded like you were debating the cross-examination of the experts. There are no experts for the defendant. It all sounded like they were talking about whether people could disagree about the standards and so forth. Like one standard marks the step one way, they mark it another way. Judge Glickman made the point, looks conspicuous to me, which is fine. But that doesn't mean it's not a jury question. It doesn't mean it's a jury question. Once you have all the facts in front of the jury, just looking at this photograph from this photograph does not make it a matter of law.
What would you say is the national standard? Do the experts, either of the plaintiff's experts, articulated a national standard?
So the standards that they cite are the national standards, the safety standards. So these are available to everybody who is using safety for purposes of managing their building. This company does not have a manager for their building who knows anything about safety. There are standards for the handbook of warnings, guidelines for stair safety, the nationally recognized book, slips, trips, and falls, the ASTM standards. These are all the standards, the life safety code. These are the standards that everyone uses, according to our experts, for safety purposes of marking these risers or any walkway.
If the standard says handrails and color demarcation, and we can look at this picture and see that both of those are there, why doesn't that sort of say, well, no reasonable jury could find that the standard of care was breached?
So it's up to a reasonable jury to determine whether this is sufficient standards, okay? You don't have the same standards consistent throughout the building, and that's a jury question.
Could you explain? Could you explain how a reasonable jury could find that the existence of the stair here was not conspicuous?
Yes, Your Honor. I can explain exactly how, because Mrs. Leach is walking the testimony, the facts of this court.
Just explain it to me how.
That's fine, because as I have to explain it by the circumstances. As she's walking, if you are in this garage, Your Honor, and you're walking across these lines, they blend in together from this angle. When the angle is that you're walking towards the stairwell, you're not seeing the barriers. They're not even handrails, they're barriers. They don't slope, even if you do see them, because the sloping indicates there's a step up. These are lines that look like they're the same width. I mean, who marks this in the same way? You don't need to mark it. It's not marked in the same way, one floor up.
By the way, I take it the lighting, there's no issue about the lighting.
We haven't raised the lighting. Have not raised the lighting.
So the person coming could see that, oh, look at that, it's yellow here.
Yes.
I mean,
And
the thought I have is that even if you don't immediately take in everything that is before you, the existence of this change in color and all this, the handrail, it alerts you that there's something there.
I think,
and you look, if you know, that's what where I'm getting hung up, I suppose, on this question of why wasn't it conspicuous?
your questions are excellent questions. Have no problem with the questions. That's what a jury is going to decide in the jury room. That's what happens. But to say that there is no issue of fact that as a matter of law, we're going to take all these facts and shut the door on these cases and other cases like it, despite the fact you got an architect, a forensic engineer, the facts indicating that there was a person acting as though this was not a conspicuous floor. And they're contradicting themselves. This business has no safety person. And they have an obvious change between one stairway, one floor up and the other one. But what do you expect if you don't have someone on your staff able to see this? The forensic engineer went there and in 1 minute, he says, the time it takes to go from one floor to the next, there is a problem with this staircase or this step. It's a problem. It would be fixed. That's all you have to say. It would be fixed. But it's up to the jury. The jury may decide your way, Judge. They may. But this court has to say, are there issues of fact, not how you would decide it, how you, Chief Judge, how you would decide it, or Judge Glickman, how you would decide it. It doesn't matter. That's not the job. I suggest to you that there are many, many facts that are in combination impossible to say a reasonable jury could not decide for the plaintiff. And that's, unless there's other questions, I'd be happy to answer other questions.
Thank you very much, counsel.
All right, thank you very much.
All right, we'd like to thank both counsel for your briefs and arguments, and we'll take the case under advisement.
Thank you.
All right, our second case this morning is Salem Media Incorporated versus Imran Awan et al. All right, good morning, counsel.
Good morning. Can I reserve 3 minutes for rebuttal?
Yes.
May it please the court, Gabriella Rickheimer representing Salem Media, Inc. We're here because Salem Media's Regnery Publishing Division, which is located here in Washington, D.C. It's one of the country's largest publishers of books with typically a conservative or religious viewpoint. Published a book called Obstruction of Justice in January of 2019. The question before the court on this appeal is, should the complaint that the plaintiffs filed against my client Salem be dismissed under the District of Columbia Anti-SLAPP Act? The plaintiffs here don't contest that the act is applicable to their claims against Salem. So that gives them a burden of proof at the outset of the case, pre-discovery, to show that they are likely to succeed on the merits with respect to each and every element for each one of the claims that they've pleaded in their amended complaint. So as a bit of a roadmap, I'm going to try to cover 3 arguments here. One, the plaintiffs are limited purpose public figures. So that gives them a higher burden of proof. And that's going to be my second argument, that the plaintiffs haven't met this higher burden of proof, the famously daunting standard of clear and convincing evidence to show that my client Salem published obstruction of justice with actual malice. And then briefly, time permitting, I'll talk about the emotional distress and unjust enrichment counts, which raise some additional issues.
I'm very curious about the limited purpose public figure argument. Why aren't they? Tell me why you think that they are.
Sure, Your Honor. So the touchstone of the public figure analysis, as this court stated in Friedman versus Orbitz, is the plaintiffs having ready access to mass media of communication, both to influence policy and to counter criticism of their views and activities. And that statement in Friedman is a nod to the US Supreme Court decision in Gertz, basically saying the same thing, that there's a dividing line between public and private figures based on whether they have access to.
Well, they didn't ask to be in the spotlight.
Pardon me?
They did not ask to be in the spotlight here.
But you don't have to ask to be in the spotlight.
Or seek it, so to speak.
Well, so let's talk about the voluntary nature of what they did. So I'll analogize to Lawrence versus Donnelly. So that was a female fighter pilot who she didn't ask to be in the spotlight, but that wasn't what the DC Circuit focused on that case. With the DC Circuit, I don't know if that's a Freudian slip, I apologize to the court. The DC Circuit focused on the fact that Ms. Lawrence chose a path of endeavor that put her in the spotlight. And so here I'll focus on several facts that we think is important to the limited purpose public figure. One, plaintiffs here worked for Congress. They held the keys to the kingdom, and that's a quote that we feature in our brief. They did work in IT. They had access both to for purposes of purchasing IT devices, as well as to have access to IT passwords and networks for the members of Congress for whom they worked. They violated security and network access and procurement protocols, and they say this was at the request of their bosses. But if anything, that just increases the spotlight or the opportunity to be placed in the spotlight. Because as we know, every year they were presented with a document to sign acknowledging that they've been
exonerated from all of these charges by the time or by the time Salem published its book.
Well, that's the question, Your Honor. Were they exonerated? And that's the question. That's the purpose of this book, to explore that the investigation that Luke Rosiak, the author, had conducted over the course of his investigative journalism. So there was a statement for sure. There was a plea agreement reached between Imran Awan and the United States government, and it contained a statement that there had been an investigation by the United States government, and they didn't find evidence. Now there's no record of what that investigation was other than what's in the plea agreement. So what obstruction of justice is a chronicle of the investigative journalism that Mr. Rosiak had conducted. It has his sources. I'll say this too. It goes through what is claimed as exoneration here. It's on the page. It talks about the plea hearing, the book talks about Judge Chutkan's statements. It's laid out there for the reader. And then Mr. Rosiak goes through and says, well, I spoke with coworkers of Mr. Awan. I spoke with his other family members.
From the perspective of the limited purpose public figure issue, I guess what I was getting at is, had their limited public status, if there was one, subsided by the exoneration, and essentially was it resurrected by the book when the book came into publication?
I think I understand your question. The book was published just a few months after the plea hearing. The plea hearing was in toward the end of 2018. The book was published in January of 2019. In Judge Chutkan's statements that she gave in her sentencing hearing, she said, I don't think this is over as far as the publicity goes. It wasn't the book that resurrected it. There was a continuing interest that we point out in our brief that there's a pending FOIA case in the U.S. District Court here in DC to get access to the records of Congress that went into this investigation. Very little has been declassified, but that case is still pending. In the view of my client, there was still very much a public interest in exploring what happened here. So it can't be that once the government says that they've closed a case, that there can't be any further exploration of those facts.
I don't think that is the suggestion. I think the suggestion is that the fact that various investigators have, quote, exonerated the plaintiff raises the question of whether the speakers in this case, that Salem and Mr. Rosiak, still had reason to believe the truth of the statements they were making. They may be correct. It may be that exoneration was wrong. But the issue here is, what is the standard? Is it malice or is it a lower standard of negligence? And if so, whatever that standard is, did the plaintiffs here show that that standard was not met by the speakers? And so the first question is, well, which standard are we applying? And that's the question, as you've indicated, whether Awan was a limited purpose public figure. What precisely, if I may ask you, do you think, or do you think the evidence shows Awan did to make himself a limited purpose public figure? I have difficulty thinking that merely by working for Congress in the capacity in which he worked, that he became a limited purpose public figure.
There are a couple of things, Your Honor. One, it wasn't just working for members of Congress, but it was the activities. It was the activities that were violation of their employment contract and violation of law in terms of the splitting of invoices and as well as the sharing of passwords, things of that
Now,
nature.
the Supreme Court has said, for example, in Molston, that you don't become a limited purpose public figure merely by having committed a crime. There's more to it than that.
Correct, Your Honor. And in Walston,
the standard, and just to say what they do say is the test is whether the person, quote, thrust themselves to the forefront of particular public controversy in order to influence the resolution of the issues involved. Now, I understand that there may be other ways that one can become a limited purpose public figure, but that language from Molston seems to get at the sense of what we're talking about here. And I'm wondering whether there's evidence here that establishes that Awan and his family members did that.
Your Honor, there were, again, there was, it's not, they did, Mr. Awan did give an interview to the Washington Post, and the photographs that are in the record were posed photographs for the Washington Post, and that was at the morning of his sentencing hearing.
Waldbaum also say that responding to press inquiries and defending yourself can't make you a limited purpose public figure?
Well,
bootstrapping the Supreme Court was worried about.
The timing is such that the book came out after this. So it's not, the book explores all of this, by the way. So it's, the standpoint of my client is at the time they published the book. By the time they published the book, Mr. Awan had given the interview and again, allowed himself to be photographed. Also his counsel and the Awan's counsel gave reports to the press. And I think you can't remove from the record the fact that these plaintiffs had members of Congress going to bat for them over and over again. So they had plenty of access to mass media communications. And so even if they didn't personally invoke it, they had surrogates to do it for them, whether it was their counsel or members of Congress. And so this is all what makes them limited purpose public figures. It's not just they were on the periphery. So Ms. Ilios,
like slice that up between the individuals, because I don't see Jamal, Tina, or Rao, I'm speaking on their behalf, or having an attorney make public statements on their behalf. So what is your argument that they might be limited purpose public figures?
Well, Your Honor, that is a fair point. These folks tend to get grouped together as the Awans, and so the argument would be that they were all of a piece, and certainly as far as the members of Congress.
I'm a public figure, my non-judge spouse becomes one. That seems hard here. I mean, I think when we're talking about limited purpose, it really is, do the specific facts make this specific person based on a specific controversy, right? And so I do you have a case saying that because one person in a family is a limited purpose public figure, it extends to the rest of them?
No, Your Honor, and I would not submit that's the role. I would say under the facts here, where all of the plaintiffs were involved in the activity that drew them into the investigations, and it were the members of Congress defended each and every one of them. It's the evidence in the record is the affidavits that were submitted on their behalf. And so very different from Ilya Walston, I would submit, Your Honor, who just receded into the background for 16 years. This was a timely publication shortly following the events. And we would say these individuals who are at the center of the controversy, nothing like Ilya Walston, and are deserving of public figure treatment.
Case law seems to sort of separate voluntary limited public figures from involuntary limited public figures, and there seems to be substantial controversy about whether an involuntary limited public figure actually exists. So do we need to decide that question to resolve this case, or are you saying that they're just squarely voluntary limited purpose?
I believe they're squarely voluntary limited purpose public figures, but involuntary public figure doctrine is alive and well. I mean, it's never been discredited by this court. It was reaffirmed as recently as in the Friedman case. And so, Your Honor, we would ask you to rule on whether there is a limited purpose public figure for these folks, again, because this was such a large controversy. We believe that the standard for our client who publishes works of nonfiction, that our client should have the freedom to publish a work like this, a nonfiction work like this. So so we would ask you that.
I know I noticed you're conscious of your time. We've asked lots of questions about this limited public figure issue, but assuming that we agree with you that for purposes of this controversy that the Awans were limited public figures, why wasn't there some recklessness to some of the allegations in the publication? I know you attach an exhibit highlighting some of the statements that were alleged to be defamatory, and where you purport to explain why you think these particular statements were supported by some source or other support.
So I two things. One, this is a subjective test. Was my client subjectively aware of a high degree of probable falsity? There's no evidence in the record to suggest that because of the sources. Two, and there are numerous cases we cite in our briefs on this point. The exoneration in the record was part of the book.
Is recklessness really a subjective test? It
is, Your Honor. It's a subjective awareness of facts that would put someone on notice of a high degree of falsity. So it can't be that objectively, I mean, there's the Hart-Hanks case in the United States Supreme Court that says even an extreme departure from professional standards is not actual malice. So it is a subjective test. And then the second point is reporting perspectives at odds. So here the book presents 100%. I think it's almost an entire quote from the sentence from the plea agreement, setting forth what the U.S. government said they found as part of the investigation. It also reports Judge Chutkan's comments. So case after case has reaffirmed that reporting perspectives at odds is the antithesis of actual malice. So and I think the third point I'd make, and we do this and we say this in our brief, that the Nader case makes clear that you can't impute from Luke Rosiak to our client. And so you have to look at our client from the perspective of the book publisher. So we see a book that's sourced. We see it reports both, so to speak, both sides of the story. And we have a journalist who is regarded as a serious investigative journalist. And so in the Nader case, this court found that the publisher didn't have actual malice because they relied on those same types of factors in saying there's no actual malice. So with the court's indulgence, I'd still like to have 2 minutes.
Absolutely.
Thank you.
Good morning, Your Honors. Deepak Gupta for the plaintiffs.
Good morning.
May it please the court. I'd like to start by just clarifying how I think the scope of what is on appeal has narrowed. I think as the court is aware, the plaintiffs have entered into a confidential settlement with the Daily Caller and with Mr. Rosiak. And so Salem is the only remaining defendant in this litigation. And as we read their briefs, Salem does not deny that the plaintiffs have satisfied all of the elements for defamation under DC law, assuming a negligence standard applies. Instead, as the questions in the argument have brought out, the central issue is whether our clients are limited purpose public figures and whether an actual malice standard applies. And we think we have shown actual malice, but we also think we don't have to. Judge Glickman, you asked, what did the plaintiffs do to thrust themselves forward and to become limited purpose public figures? And the principal thing I heard from my friend was she pointed to a Washington Post interview that Imran Awan gave. And I think it's very important to explain the timeline and to contextualize that interview. The defamatory campaign began in the first week of February 2017. The Awans were unknown until that time. That was when the first reporting occurred, when Mr. Rosiak named my clients. From that point in time until August 2018, there was a flurry of allegations, controversy, publicity, led by the Daily Caller. Throughout all that time, none of the plaintiffs said anything publicly to defend themselves. They avoided all press. Then in July of 2018, you had the plea agreement with the Justice Department, and the Awans thought they had been exonerated. They thought these allegations had been thoroughly investigated and that they had been cleared. And so in August 18, on the day of the hearing before Judge Chutkan, after they thought this whole thing was over, Imran Awan alone gave one interview to the Washington Post. So as Judge Ali Khan pointed out, none of the other plaintiffs have ever given any interviews to the press.
Well, public figure, whether someone is a public figure or a public limited purpose public figure is not tied just to whether they seek press or are in the press.
That's certainly true.
I'm looking at some of the language from the Friedman case, whether they achieved a special prominence in the debate and whether they were purposely trying to influence the outcome or could realistically have been expected because of their position in the controversy to have an impact on its resolution. I think that's, to me, gets closer to an argument here as to why they may or may not have been limited purpose public figures.
Right, but the focus in all of these cases and in Friedman as well is on whether there was a pre-existing controversy before the defamation and whether the plaintiffs had put themselves to the forefront of it. So in Friedman,
there's a pre-existing controversy here.
Well, it depends on when you look at it depends on when you look at the timeline.
The resolution of the court case arguably didn't end any controversy. It may have resolved in the litigation, some of the issues, but the controversy, which had received some news coverage prior to the court resolution, arguably may not have been resolved.
Right. I think the situation here is very similar to what the Supreme Court faced in Woolston versus Reader's Digest. And the court said it candidly that it was difficult to define precisely what the controversy was there. One way of looking at it, and I think you could do that here, is to look at the controversy from the point in time in which the Awan's names were first reported and the allegations were made against them, and there was a flurry of publicity surrounding the guilty plea. That would be to look at it, from 1958, from that vantage point. And that's what the Supreme Court ultimately did in Woolston. It said, we don't need to define precisely what this controversy is. We'll take the other side's view of the controversy. These people were not public figures, even at the time of that flurry of publicity. They bracketed off the question, which was Justice Blackmun's rationale, which is that even if you set aside whether they were public figures at the time of that flurry of publicity, they weren't after the exoneration and by the time of the book publication. We think both arguments are available to us here, but the principal submission we're making to you is that none of these plaintiffs were ever public figures for the same reasons as in
Mr.
Wollston.
Gupta, about all of the statements that Imran's lawyer made. I'm thinking in particular JA 420 through I think about 440. There are just lots of statements about this is a right-wing media-driven conspiracy and this is politically motivated. And I guess how, if they themselves did not inject themselves into the controversy, what are we supposed to do with these statements, which seem to be going beyond just sort of mere defense and into kind of having a real conversation in this controversy?
So I'm not aware of any case law that says, and I think this goes to a question you asked my friend, Judge Ali Khan, I'm not aware of any case that says that other people who defend someone can make that person a public figure, whether it's a lawyer or some other person who speaks out.
But don't we have to
on their
attribute
behalf.
those statements to the client? I mean, it seems like in all other contexts, we attribute the statements of the attorney to the client or impute their conduct to the client.
So as I said, I'm not aware of any case that holds that someone is a public figure on that basis, but I am aware of case law that forecloses public figure status on the basis of press statements that are made either by the plaintiff or by their counsel once the defamation has occurred. And I think there are three cases I would really point you to. The Supreme Court's decision in Hutchinson versus Proxmire, the Supreme Court's decision in Time versus Firestone, and the DC Circuit's decision in Clyburn.
But most of these statements were made before the defamation, right? Because you're saying the defamation occurred with the publication of the book, and these are all statements around the time of the indictment.
I think the better way to understand this is, as I was trying to say earlier, is I think that it's better to view this as a single defamatory campaign. I mean, understand the litigation with Mr. Rosiak is now settled, but he was the author of this book, and it's the same substance, you know, the same allegations that were being bandied about from February of 2017, and that culminated in the publication of this book. And so I think there are two ways to look at it. One is it's a single defamatory campaign, and they were attempting to defend themselves. And I think Wollston holds that, you know, attempting to defend yourself once you've been defamed does not make you a public figure. And then these cases that I just mentioned more specifically drill down on this question of, you know, what happens when you are being accused of something and then you make statements in response. So in the Hutchinson case, Hutchinson, the plaintiff, made statements that were picked up, and this wasn't his lawyers talking, this was him himself, were picked up by the press and the wire services, and he defended himself from the accusations. And what the court said there is, you know, making that kind of defense once you've been defamed doesn't render you a public figure, because his access to the press, such as it was, came because of the accusations.
So do we have to decide, I know I asked your friend on the other side this question, whether they were voluntary versus involuntary limited purpose public figures?
I think, you know, if I understood the answer to the question correctly, I think that my friend is resting principally on the notion that they were voluntary public figures. I think if you do reach the question, it is our view that there is nothing left of the sort of so-called involuntary public figure doctrine. That doctrine, such as it is, rested on a reading of a single sentence in Gertz, which hypothesized that in extremely rare cases, there could be involuntary public figures. But that decision came before 3 Supreme Court decisions, culminating in Wollston. So
can I take you to your assertion, I think at the beginning of your time, that you feel that you could satisfy the malice standard if we determine that your clients were public figures or limited purpose public figures. Can you walk us through how you would do that? I mean, it seems one could argue that this is just a different point of view presented in the book that is contrary to the view that your clients held. And that seems to get squarely at the First Amendment, that people should be able to say what they think, even if it differs, disputes, disagrees with what others may think. Your clients point to specific statements in the book that were defamatory. And in one of the exhibits to opposing counsel's brief, they sort of walk through each of those statements and offer an explanation for why they think the statement was supported by some sourcing. That seems to, as they argue, get them out of the realm of reckless disregard for the truth or intentional disregard for the truth. and defeat an argument that there was malice here. What is your response to this?
Okay, I have quite a few responses. Let me
I thought you might
get them all out. So first, I do want to just point out, Chief Judge Blackburn-Rigsby, that the recitation that you're talking about, and this was kind of what I was getting at the beginning, that's in Mr. Rosiak's brief. It's not in Salem's brief. So I don't think that is that point-by-point refutation is any longer in the scope of this appeal. The appeal is narrow.
I take that point, and then the bigger argument about the publisher's
I may be mistaken,
right
but I think that in appendix 2, perhaps I'm mistaken. I think that in appendix 2, Salem's brief also contains something of that nature.
Yeah, there's a version of that. So I think if you disagree with us that our clients are private figures and you reach the actual malice question, then I think to answer Judge Glickman's earlier question, there is a component of the analysis that does not just turn on knowledge of falsity. The Mann case, I think, explains this, that the plaintiff can prove inferentially that there was recklessness. And the Supreme Court's cases have pointed to two ways that plaintiffs can do that. One is when there is what the court has called obvious reason to doubt the veracity of the statements. And the other is when the publisher's allegations are so inherently improbable that only a reckless person would have put them in circulation. And we think both things are present here, that this is not just, respectfully, not just disagreement on some point of view or controversy. These are very serious allegations, the most serious kind of allegations that you can circulate about someone, that they were guilty of this whole series of crimes. Any one of these things taken in isolation is improbable, but collectively, the idea that they did all of these things and that the Justice Department and the FBI did the kind of thorough investigation that they did. And I do think that the investigation is detailed in the plea agreement. The government went out of its way, and it's extraordinary for them to have done this, to detail that they looked at all of the servers, they interviewed 40 witnesses, that they forensically examined all of this. They investigated not just Imran Awan, but the whole family. And they concluded that there was no wrongdoing in connection with these allegations. And so in the face of that kind of exoneration, that presents obvious reason to doubt the veracity. And that was, that was what was going on in Mann, in this court's case in Mann, and also in the Nader case. Both of those cases, you had investigations, and the court held that that is obvious reason to doubt the veracity. Now, it doesn't mean we win. It means it goes forward to a jury.
I know Rosiak and the Daily Caller are out of this case. It seems like you have a harder road to hoe with Salem as the publisher, because I think what you're really suggesting is that these statements were, sort of fell below the professional standards of a publication company. But I think doesn't the Hart-Hanks and a few other cases say that isn't sufficient when you're dealing with a limited purpose public figure?
I actually think it cuts the other way, Judge Ali Khan, for a couple of reasons. One is when Rosiak first circulated these allegations, he didn't have a government investigation. When Salem published this book, this was in the cold light of day. There wasn't a flurry of publicity. They weren't facing the kind of pressures that beat reporters face. They weren't facing deadline pressures. And Justice Blackmun mentions this in his concurrence in Woolston. He distinguishes between the kind of pressure that newspapers face to get things out on deadline and the ability of a book publisher, like the book publisher in that case, to investigate and check and ensure that statements are accurate before people are accused of serious things like crimes. So I actually think it cuts the other way. But ultimately, the actual malice standard is the same for a publisher or for anyone who's putting things out there. And when you have obvious reason to doubt the veracity of the statements, it's incumbent on them to investigate. They don't have a freestanding duty to investigate, but they do when that is the case, as it was here. And what that means is that there are questions of weight and credibility that are not for the court to decide, but that would be for a jury to decide. I think it's important to emphasize that we are just at the threshold of this case. We filed our complaint, and because of the SLAPP statute, we have to demonstrate that that we can go forward and that we're not foreclosed as a matter of law. We think we've done that.
Can I ask you,
regardless of the standard of fault?
Your time, I know we've used a lot of it with our questions, but I'm curious about the two other counts, in particular, the unjust enrichment claim. Is that a separate claim? I've never seen an unjust enrichment claim, which is an equitable claim for relief, where there wasn't a quasi-contract type of dispute, and we don't seem to have that here.
Right, and I think candidly, there's not a lot of District of Columbia case law that's directly on.
Is there any? Because I
think there is. So I think what my friends are saying, they're making two basic legal arguments for why they think our claim is foreclosed. The first thing they are saying is that they think it is a requirement of DC law that the plaintiff have conferred some benefit on the defendant. And the second thing that they are saying, and I think is embedded in their argument, is that the claim is unavailable when there is an adequate remedy at law. And there is actually a case of this court, it's a very recent one by Judge Deal. Judge Glickman, you were on the panel, and I'm sorry we didn't cite this in our brief. I just discovered it in preparing for oral argument, but it's called Glasgow versus Command Management. And it stands for the proposition that it is not under DC law a requirement for unjust enrichment that the plaintiff have directly conferred the benefit. And so I think that forecloses that argument. Also, restatement section 44, District of Columbia follows the third restatement on unjust enrichment. And restatement section 44, I think, governs this kind of claim. It says that a person who obtains a benefit by conscious interference with a claimant's legally protected interests, and that can include tortious conduct, is liable in restitution as necessary to prevent unjust enrichment. And then with respect to the point that they make about adequate remedy at law, I just want to make sure I get this across because it may be surprising to some folks. But section 4 of the restatement says a claimant need not demonstrate the inadequacy of available remedies at law. So I think those two sections of the restatement dispose of the only legal arguments.
But are the
Salem
remedies at law inadequate here? I mean, if you prevailed on your defamation claim, you could get damages and perhaps even punitive damages. Why wouldn't those be sufficient to compensate your client?
So first of all, just to be clear, what the restatement is saying is that that is not a requirement for unjust enrichment. But let me just answer the question then. The unjust enrichment claim is seeking something different. So the unjust enrichment claim that we are bringing is saying you did something, regardless of the actual damage that is cognizable at defamation. You took our names, you took our stories, you turned them into a product for sale, for profit, with Imran's face on the cover of that book, and then you derived profits from doing so. It's akin to when somebody has a claim based on their right of publicity or an intellectual property claim where there are profits that are derived at the expense of the plaintiff. And so it is that kind of theory of remedy that's being vindicated by the unjust enrichment claim. And I think that's distinct from the defamation claim.
So we have said in a case called Randolph Bray that equitable relief has to only be available when there's not a complete and adequate remedy at law. So are you saying that that is essentially just inconsistent with the restatement, or that unjust enrichment is special?
No, I think what the restatement is saying in section 4 is that unjust enrichment and restitution remedies derive both from law and from equity. And so the idea that there's no adequate remedy at law, that's a statement about equitable remedies, and that's still correct. But it doesn't mean that it forecloses a remedy for unjust enrichment under the restatement. So I think you can totally reconcile that understanding with your case law.
And then do you have a cite for the Glasgow case?
Yes, Your Honor, that's 261 A3rd 208. And if you look at page 221, I think that explains it pretty well. That was a case, it was a very different kind of case, but it was a situation in which somebody pocketed some money. They hadn't gotten it from the defendants, and the court said that doesn't foreclose your unjust enrichment claim.
Chief, if I may, I realize we're beyond the time limit, but if I may, I'd like to pursue something with counsel briefly. Getting back to the question of whether Mr. Awan was a limited public figure. Counsel, your opponent argued that he was such, basically by virtue, even before he was responding to any defamatory accusations, I take the point that responding to defamation does not make you a limited purpose public figure. But counsel was arguing that he really became a limited purpose public figure before that by virtue of the job that he was performing and the fact that that job led to an investigation and various consequences for his business. Now, there does seem to be something to that in the sense that the proper performance of governmental duties is a matter of public concern and can properly be explored in the public, in the press, for example, and in public. So how do you respond to counsel's argument that from then on, in effect, Mr. Awan was a limited purpose public figure?
So there is a distinct concept, I think it's important to clarify, that is the concept of a public official, which is distinct from a limited purpose public figure, right? I didn't understand them in their briefing to be making that argument, and I think for a good reason, because what the case law on what constitutes a public official tells you is that not just any government employee, I mean, most of the District of Columbia would be a public official if it were just any employee. There are people who do IT work in this courthouse. I'm sure they do it, they faithfully and with an understanding that they're doing a public service, but they're not public officials. And so what the case law on public official, that concept tells you is that it's people generally with supervisory responsibility, higher level officials. And I think that's why my friends on the other side did not make the argument, because low level IT people, these are people who fixed your printer, who fixed your email. They were in a small cubby office on the 3rd floor. They were not interacting with constituents or with the press or doing any policy making. They were in no sense public officials. And so
just to explore this and nail this down. So if the press got wind, for example, of this internal governmental investigation and the termination of their contract and the like, and the Washington Post thought, well, this is, some potential significance, that's interesting, writes an article about it, interviews the people involved and so forth. That would not be enough. And let's say Mr. Awan is interviewed and he says, we don't think we did anything wrong.
Right.
Whatever. We were doing what our bosses told us to do, whatever they want to say about that. You would say that is all not enough to make them, for purposes of defamation law, limited purpose public figures.
Absolutely right. And if you want to look at a case of yours on this, I think maybe the best case to look at is Moss versus Stockyard. That was a case where the person was much more senior. They were actually, the head basketball coach of a public university, and they were accused of actually pretty similar things. They were accused of violating internal rules with respect to procurement and expenses. And the court said, you're not a public official, and this controversy over whether you violated those internal rules does not make you a limited purpose public figure. Thank you very much.
All right, thank you, counsel. All right, Ms. Rickheimer? Rickheimer.
No worries.
Thank you, Ms. Rickheimer.
I'll be as brief as possible, just to tick through some of the issues that came up. I'll maybe just go in reverse order because that's the easier. Moss versus Stockard, correct. It was a coach of a women's basketball team. The court commented that there wasn't much of a public controversy to begin with, and the plaintiff did not attempt to put her side of the story out to the press. The facts here are that this was a public controversy. It wasn't just reported in the Daily Caller. The records replete. There are articles in the New York Times, the Washington Post, Politico. The interest came because there was a public statement put out about this investigation. That's how BuzzFeed started reporting on it. Before Luke Rosiak, there was a high degree of interest in this story on the part of the public. The timing is important. Our book was published in January of 2019. We weren't part of any sort of multi-year defamation campaign. That's the plaintiff trying to impute facts that belong to Luke Rosiak to us, and we say that's inappropriate. I think the other point, statements by the attorney. I mean, there was statements by Mr. Awan's attorney in the press that were put out there. They did go beyond just defending, and there was an audience for this because there was an audience for this. There was a great deal of interest in it. So there was no, again, the mass channel.
What do you make of your friend on the other side's argument that the lawyer isn't actually the same person as the speaker?
It's agency law. I mean, there's no argument that they were unauthorized statements. There were arguments that obviously they were helpful. I mean, there was a lot of positive publicity in the press, and I'll get back to my touchstone point, that the reason you have this walled bomb test is a way to try to encapsulate some sort of test. But the touchstone is, did they have access to mass channels of communication? And certainly they did. There was a great deal of very favorable publicity that included statements by at least Mr. Awan's counsel. I'll say on the, and Judge Glickman, you're correct. We put before the trial court and we put before this court point by point, every statement they identified as defamatory, we identified the sources for those statements. Additional evidence came in, and it's in the joint appendix. We did cite to it in our reply brief. It's before the court. We think that's sourcing. There's a quote in Nader that says, comment on public affairs is the essence of self-governance. So the fact that there is a plea agreement out there, this very public statement by Judge Chutkan, it doesn't make the controversy go away. It still makes it interesting. It makes it important to comment upon. And that certainly was our client's goal in publishing this book, in a way to bring to life the serious questions he believed existed about the scope of the government's investigation.
Did you have anything? We didn't ask you at all about the, much about the unjust enrichment claim. Typically these unjust enrichment claims arise in a quasi-contract kind of way. But in this instance, I can certainly see the reason for seeking disgorgement of the profits that your publishing company made from a book, saying that despite the plea agreement and the investigation, that the Awans were still essentially involved in criminal activity. So if they were to prevail on a defamatory claim, why wouldn't they, or shouldn't they be able to get disgorgement of the profits of the book that was the vehicle for that defamation as part of their damages?
Understood, Your Honor. Gertz versus Robert Welch speaks to this. And so in addition to this court's law, which is putting aside what the restatement is, what has this court said about the law? And this court is, Judge Ali Khan, you took a note right out of my outline here from the quote from Randolph Bray. So we would suggest to Your Honor, unless you're going to change the law is what this court has said it is, not what's in a restatement. But let me go back to Gertz versus Robert Welch. Redress for defamation, quote, extends no further than compensation for actual injury. So the unjust enrichment isn't an actual injury. So we would submit that unjust enrichment, in addition to not meeting the elements that this court has set forth as the test, it's constitutionally impermissible. Thank you.
All right.
Thank you very much. I appreciate the court's time.
All right. We thank both counsel for your briefs and arguments, and we will take the matter under advisement. Thank you both. All right. Our third and final case this morning is Priyaman John versus Harshit Agarwal. All right. Good morning, counsel.
Good morning, Your Honor. My name is Paul Smoller, and I'm representing the appellate and the plaintiff, Priyam Jain, and I also represented her in the trial court. The issues that we're asking the court to reverse are the award of alimony, both as to the amount and duration, and the award of a 15% interest in Dr. Agarwal's dental practice, along with the computation of the value of appellee's interest in the practice. So I gotta say at the beginning, I know this is a challenging appeal, because I know that to ask this court to reverse a family law decision where the trial courts have been afforded considerable discretion in entering their decisions and finding their facts on the grounds of abuse of discretion is a very formidable task. I mean, I've been around long enough to know that the Court of Appeals is very, it's not lenient, but it just looks very closely as to whether there has been an abuse of discretion. But I do submit that in this case, I think we've shown it. And so if the court agrees with my statement of facts, and you can see I spent a lot of time in the brief, number of pages, and in the reply brief, going through the trial record, the testimony, documents, and set out what I think is, and what I would submit is an accurate statement of the factual record in this case. And if the court believes that, then and finds that to be accurate, then I would suggest that the decision has to be reversed. It's just not supported by the record. You know, often the trial court considers factors in the statute for alimony and equitable distribution. And if they consider the factors, then the court will then uphold the trial court decision. However, in this case, the trial court did discuss all of the factors. In fact, it cited the same evidence in support of each factor for alimony and equitable distribution.
Counsel, can I jump in and ask you a question about the trial court's adoption in the final order of essentially the same amount of alimony on a temporary basis as she had awarded in the Pendente Lite alimony award. It didn't appear that you pushed back much on that at the trial level, saying that that was not appropriate in the final order.
Well, we actually, it didn't come up during the trial,
yes,
what she was going to do. We did push back because we asked for $7,500 a month in alimony. And in fact, the court thought that was an unreasonable ask. We also proved in the court at the trial level that Dr. Agarwal's income for 2020 was about $480,000, and for 2021 was about $450,000.
So your argument on appeal is that the amount of alimony was improperly calculated and insufficient in amount and duration.
Yes.
Because of Mr. Agarwal's net income at the time.
Well,
or gross
net was never found by the trial court. You know, what's curious about the income argument is that in one paragraph and one paragraph only in the entire decision, the court found that was his income. A large part of the trial was devoted to proving that income, because in the PL hearing in September 2020, he had said that he was only earning $220,000, and so we were faced. And in 2021, he was saying, I think he said somewhere around $217,000 in 2021. So we had to bring in a lot of testimony to show what he actually earned in both of those years.
So what I'm trying to zero in for our purposes on why or in what manner did the trial court abuse her discretion in the alimony award? Was it an error because it was a miscalculation of Mr. Agarwal's income? Was it abuse of discretion because it didn't account for certain factors that should have been accounted for?
It's not an easy question to answer because there's a lot involved. One of the things is the trial court never found net incomes. never considered his net disposable income in terms of
But where does it say that just because he might have higher income, that she gets a higher award? I thought that the alimony was what was sort of reasonable to maintain, not that if he has a practice that is growing, she's entitled to a larger share of that.
Sure, it's the ability to pay and the need. And we showed that the need was 7,500 or so, and that his ability to pay was far in excess of that. And one of the
court found that he had the ability to pay. So I guess I'm just wondering, why does his specific income matter?
Because that's what you use for the ability to pay.
Right, but the court found the ability to pay. I presume you don't doubt.
I'm sorry, what?
The court found that he had the ability to pay alimony, and you don't, I think, take issue with that finding.
I'm not sure the court actually made that finding, but if the court made that finding, I wouldn't take issue with it. What I would say is that you have to look at a number of factors. One is the standard of living. One is the employability, ability to work and ability to earn in the future. One is
I have some questions about her earning capacity. Is it my understanding that she lost her ability to live and work in this country once the divorce was finalized?
According to, well, the expert said there were several ways that she could stay in the country, but employment would be very difficult. But yes, once she was divorced, under the law, she lost her ability to work because she would have to leave the country within a certain amount of time. Though there were circumstances that the expert said where she could stay, but it was clear that in order for her to work from the moment she entered this country, she needed a work authorization permit, and and she did get that eventually. And then she needed to find an employer who would apply for an H-1B visa for her. And in doing that, they would have to pay for the visa. They would have to submit that the job, apply for exemption so that she could work for them. They would have to submit all of the requirements of the job and show why they specially needed her.
But she was allowed to work on her H-4 visa for a number of years and did not, correct?
She did work. She had one job. She worked with her aunt.
Right, that was her H-1B sponsorship,
right.
But she also had work authorization under her H-4.
That's right. Her aunt hired her and applied for the H-1B4 visa. They obtained that in January of 2020. And then in June of 2020, because the aunt's business, as I said in the brief, depended upon receiving jewelry and other products that were produced in India by Indian women. It was a women's-based organization. It was COVID, and imports didn't come in.
And when she lost her employment with the H-1B sponsorship, did that mean that she could still work under her H-4 work authorization?
Only if she found an employer willing to apply for an H-1B.
Maybe I'm missing
once
something.
She lost her in August of 2020, she lost her right to work because the H-1B visa went by the boards once the employer left, and the work authorization also need to be reapplied for.
Right, but she could have reapplied for work authorization, and I think did apply under her H-4.
She did, and she got in July of 2021, the expert said right before the trial that she now had the ability to work if she could find an employer who would once again apply for an H-1B visa and would meet all the requirements of applying for that and pay for it.
I'm sorry to keep pressing. I just want to make sure I'm understanding this because immigration is not my area of expertise. So my understanding is that her work authorization under the H-4 is distinct from her H-1B. And so that, yes, now that she is divorced, she's no longer entitled to H-4 status, but that prior to the divorce, she could work under her H-4 without her employer needing to seek an H-1B. H-1B is a sort of permanent path, with a particular employer, but she had a work authorization under the H-4.
That's not what the expert said, Your Honor.
Okay.
And all I can do is direct you to her testimony, which she quoted. She was the only immigration expert, and she said that once in August 2020, once it expired.
Oh, to be sure, because she let it lapse, right? But she could have.
Well, she couldn't. she had to apply again, and she did apply again, but she was her status was somewhat contingent on her husband's status, and he delayed in applying until middle of 2020. And then when she finally, after August of 2020, she had made an application, but it takes time. It took a lot of time. And it wasn't until, I think it was June or July of 2021, that the expert said that it had come through and she could now proceed to find an employer, not the H-4, but she had a work authorization. So now she could proceed to find an employer to hire her, and the trial was August.
Counsel, can I wanted to go back to my earlier question. I'm trying to clarify the relief that you seek from this court. Are you asking us to reverse and send the case back to the trial judge to recalculate the amount and duration of the alimony? Are you asking us to decide what the amount of the alimony should be? Because that, of course, is not something that we could do, even if we were sympathetic to the notion that the alimony award should have been for a longer period of time and in a greater amount. So I guess legally, what remedy would you seek from this court? I'm wondering if the argument made below that for the reasons that you stated, Ms. Jane's immigration status was in flux, either requiring her to return to India if she couldn't get work, or I think that's the issue with the immigration status. Doesn't that factor cut in favor of extending alimony rather than decreasing the amount of time? And was that argument made?
Would actually could be involved. It could involve both. One, it would require extending duration, and it would also require, I think from the beginning, requires revising it. The question of what to do.
But was that argument made to the trial judge that because Ms. Jane's immigration status was in flux upon the finalization of the divorce, that required a greater amount of alimony for a longer period of time so that she could get settled or resettled here or resettled back in India?
My recollection is that I requested, I'm sorry, I meant to reserve a couple of minutes. I requested, we requested 4 years of alimony at the time of the trial. And we requested $7,500. The $2,050 in cash was clearly not acceptable. I mean, it just was not, it would not support her. And the problem with the duration that the judge entered was that there was no termination on it.
Okay.
It had no definite termination. So yes, we asked for 4 years. Yes, we asked for more. And what to do now with it? You know,
well, Mr. Smoller, I was going to say, I've been listening, I think, as carefully as I could. And I don't think I've heard you articulate in the argument yet what exactly in what way the judge erred.
That's my question.
In ruling with regard to the duration and amount of alimony, or in ruling with regard to the 15% share of the practice. What were the judge's legal errors?
Oh wow!
With regard to those, because as I say, I felt like I haven't heard yet in this argument.
And just to reiterate, that is the question I just asked you and asked earlier.
I devoted a large part of the brief.
I read the brief. I want to hear you talk about it.
Okay. The legal arguments.
Tell me what how the judge erred.
The errors were she made a finding that had no basis in the record that Ms. Jane would be able to return to India, become fully employed, and become fully able to support herself. There was nothing in the record about that. Nothing. She made the finding that she could be. She never took advantage of her MBA and her H4 EAH prior to August, but she did. And what's even more important, Your Honor, is that Dr. Agarwal presented no evidence whatsoever of any job opportunity throughout the marriage that she could have taken and she didn't take. There was no evidence on the record. No employment expert was presented.
Is that necessary to get that granular, or is it more that she had a significant amount of education and prior experience that would allow her to find a job in her field? I'd not understood that the inquiry was that the opponent of alimony had to point to a particular job that the person didn't take. I thought it was more just about their education, their experience, and their kind of ability to be marketable at a higher level.
If they're going to claim that she's voluntarily impoverished, which is what the court said, if they're going to claim that she's unemployed and she should have been employed, which is what the court said and what Dr. Agarwal said, then she made applications for jobs, a lot of them, they're in the record. And by the way, one of the problems was the court cited two documents that were never offered and never admitted into the record. And that's in the brief. I said, I pointed that out for the decision that she didn't believe that she could have worked. And those documents were not in the record. But to go back to your point, I'm sorry, that interruption. This may get to it, but she also, the court, I may come back to you because I'm sorry, I just forgot. The court also found that she would be able to live off of her PL temporary alimony until she relocates, and she could also live off the proceeds that she was getting from the property, which is contrary to DC law, in that you're not required to live off of your assets when your husband is able to, or the paying spouse is able to provide support.
But haven't we also held that equitable distribution is perfectly fine in lieu of alimony? So, I mean, we have cases where we've just said, all you get is the proceeds from your house.
If it produces income, I mean, that's a rare case where equitable distribution is okay, because you have to prove that it produces income for persons to survive off of them. Those are high asset cases. And this was a case where the assets that she got that she was getting were a large part were an IRA, and she couldn't use an IRA to live off of. And the judge was saying that the $2,050 a month, once the unit was sold, the house was sold, would be enough to support her. That's just, as long as she used her assets in addition to that. And she can't do that, when he's able to support her. It's just not consistent with DC law that you have to be required to do that. That's the Skiff decision and the Foley decision.
So what about the Sudarth decision? Sudarth versus Sudarth is a case I'm referring to that says that it's an equitable distribution of property, just a sort of net sum from the sale is perfectly fine in lieu of alimony. It doesn't have to be income producing.
If you can find that it produces income to live off of, if you find that it's sufficient assets to live off of, if you find that she can support herself, that's not this case. That case, I don't remember it exactly, but any cases where there have been issues about equitable distribution replacing alimony, the courts have to show that they could live off of the income or distribution income from those assets. For instance, it commonly occurs if you're getting a couple $1 million in an investment account, and it can produce $50,000 a year in dividends and interest, then the court could say that's sufficient. But when you have a case where there's an IRA, which produces no livable income, and a small amount of income, which, of another asset, which produces no income, then you can't, the courts will say that to protect the spouse who's getting it, you can't say that satisfies the alimony obligation. They must be able to live in the standard to which they're, I want to get back to your question because I just realized they must be able to live in the standard that was set up during the marriage, and $2,050 a month is not that standard. She also said, Your Honor, that I don't know why she said this, but she said that the fact that the plaintiff was working in Mumbai prior to the marriage, when it became clear her future would involve being a wife of a dentist in a well-regarded university in Milwaukee, she stopped working. There's nothing in the record to support that. She said that the appellate, that Ms. Jane could have worked if she really wanted to. The only person she found who would hire her, who would apply for an H-1B, was her aunt. And the aunt had a business and they were creating a business. And it was actually going fairly well, even though she wasn't making a lot of money at it, until COVID-19 hit, and the goods that were being produced by Indian women that they were selling could not be sent to the United States. So her business fell off, so she had to let her go. There's another point is that Dr. Agarwal said in a very curious statement at the Pendente Lite hearing in September of 2020, he offered Ms. Jane's resume into evidence as evidence that, and her evidence of her work with Prestige, his dental practice, as evidence that she was qualified to work. And indeed, it's an impressive resume. And the judge found at the September 2020 hearing that she had worked at Prestige from 2015, in admitting the document, from 2015 to 2019 as a business executive, and that she had also created their website. So that's what the judge found in admitting the resume in September of 2020. At the trial in August of 2021, we offered the resume, and Dr. Agarwal testified that even though he had seen the resume and reviewed it before she had sent it out, that it did not contain truthful statements about the work she'd done there. And that if a prospective employer called him because he was the reference, he would tell the prospective employer that the resume was not truthful. So here's a resume that he reviewed when she was sending it out and knew she was sending it out. And now he's saying, if they call me, I'm going to tell it it's not truthful. And the judge said, that's fine. The judge had no problem with that. That's a true catch-22. She's never going to be able to get a job if you're going to work back to your, on that basis. There's also the problem that the judge must have forgotten. We made the point, by the way, this was a huge point made at the trial. When the resume came in, we clarified that it was the exact same resume that was submitted in September 2020. And it was the exact same resume that was being submitted now. And that the court had admitted it in 2020, saying that she had worked for them for 2015 to 2019 as a business executive. All of that was made clear on the record at the time that it was admitted. Forgotten when the opinion came out. I don't know what happened in the intervening 8 months between the closing argument and the issuance of this decision, but when we read it, it didn't sound like the same proceeding we've been in, and there were things in it that were so different from what the judge had said during the hearing. Evaluation of the business, the judge made we had two experts, competing experts. The only thing the judge said about our expert was that our expert disagreed with the other expert. No other explanation. No explanation as to where the disagreements were. No explanation as to what was more important, what our expert's consideration was of the factors and why the judge was going to reject them. Extensive discussion of their expert, but none about our expert. So we had no idea. I have no idea. I can't argue to the court, about valuation of business. I don't know what the court would have said. I don't know what the trial court was considering. So, but the law is pretty clear that there has to be, if you're going to reject an expert, there has to be something clearly stated about why you're rejecting an expert. That was never done in this case. And there's some tax court cases that I cited in our brief. One of them points to a component of valuing a business like this, which is you got to look at the real world scenario. You got to consider what will a willing seller and a willing buyer really do in a real world scenario. And that's what our expert approached it. That's the way they approached it. And our expert said that Dr. Agarwal would probably accept an offer in a real world scenario for 90% of the value of his business. Their expert said that he would accept an offer for 57% of the value of his business. Never considered by the court. That evidence was before the court, never considered. It was argued, but never considered by the court. Also, the fact was there that it's a business that produces a net cash flow, according to their expert, I don't know, something like $250,000 a year. And according to our expert, it was something like $230,000 a year. So it has a substantial net cash flow it produces, which goes into and should be factored into the decision about what the real value is of the business.
Mr. Swaller, I know you reserved some time for rebuttal.
Okay.
And we will make sure you get that time. We've asked you questions that have taken you past your allotted. We've asked you questions that have taken you over your allotted time, but we will give you additional time for rebuttal, unless my colleagues want to ask any follow-up questions now. Okay, thank you, Mr. Swaller. Ms. Fogel?
Yes, good morning, Your Honors. Joe Fogel, may I take off my mask?
Yes,
thank you. Joe Fogel on behalf of the appellee, Dr. Harshid Agarwal. I'd like to just head right in to, based on the court's questions and the standards here in terms of a review are so well known. But I think that let me work my way backwards. With regard to the expert testimony, the judge concluded accurately that both of the experts agreed on just about everything except two things, lack of control and lack of marketability. And in preparing, I went back, she didn't ignore anything. She listened carefully. And in fact, in going back through the testimony of each expert, Mr. Pennington, the plaintiff's expert, started off by comparing his report to Mr. Nelson's. And the judge then listened to both their testimony, and 8 times during Mr. Pennington's testimony, she asked him questions about the issues of control and marketability. And Mr. Nelson, she had 11 comments interjecting in the testimony. So the idea that I don't believe there's a case that says she's required to describe a rejection, but in fact, she did compare and she did go into those two issues. And addressing the real world issue is that this is a partnership dental practice in Northern Virginia, so that any buyer had to be a licensed dentist in Virginia. And there was a lot of discussion about that. So the idea that the judge didn't indicate why she rejected it, she spoke to only the two differences. And then if I may circle back, both of the experts in their reports had access to all of Dr. Agarwal's ledgers, income, expenses, and the partnership. And they, in fact, were consistent and not disagreeing about both the cash flow and the income paid to each of the partners, the distribution to each of the partners. And in fact, both found that there were no adjustments necessary because this was a straightforward dental practice and there weren't the usual shenanigans.
In your view, the issue about the valuation of the practice and the testimony from the respective experts. What does that relate to? Does that relate to just the amount of alimony that Ms. Jane was entitled to, or does it relate also to the percentage of the practice that the trial judge awarded her?
The expert testimony was presented just for valuation purposes and the partners, the issue of the 6.1 paragraph in the operating agreement that required the other partners to have the first choice. So in the question that was raised with regard to alimony and ability and his income, there were no arguments at the time about what Dr. Agarwal's income was. It was shown on his financial statement. To my recollection, it was not a point of controversy. And as Judge Ali Khan has pointed out, we're not arguing that there was a finding that he had the ability to pay. So again, Judge Soltis was just so thorough in terms of the original findings of fact in the Pendeni Lighty, our joint statement of findings of fact, and then her additional findings of fact almost 2 years later.
So it strikes.
I just wanted to ask one quick follow-up. What, in your view, did the trial judge base her finding and conclusion that Ms. Jane could certainly find employment back in India? Was there any indication of?
I think my recollection of it, as well as the transcript, is that there were various problems presented by the plaintiff when she had the ability to work. And then she had this small hiatus. We had no idea, we meaning the defendant had no idea that she had applied for an extension of her visa. So we went into the Pendeni Lighty hearing with one set of facts and didn't find out the others till the hearing. And there was testimony by the expert that she would have had to go back to India to have her visa approved, but then in cross-examination, she could have gotten permission to go somewhere besides India. And I think there was also the cloud, if you will, of COVID, so that everybody's life was in flux. And in fact, Dr. Agarwal was shut down and was very concerned about his income. Turned out not to be true, which then was proof, at the later hearing. But in terms of that she could go back to India and work, I think that
I didn't really see any factual support in the record for that assertion by the trial judge. And that's why I'm inquiring. The notion that, of course, you should be able to go get resettled back in a different country, even if it was your home country. And of course, you should be able to find work. I don't see any basis in the record for that assertion or finding by the trial judge.
I would submit, Your Honor, it's there in her very extensive resume and her educational qualifications. In addition, both Pendeni Lighty and at the hearing, she talked about all of the things she had done. And they were all business related.
Right.
And in addition, I believe
there's a lot of people have education and talent and abilities. But in terms of the context of a divorce, where you've come to a new country, you've gotten married, settled, you're now getting divorced with the prospect of having to leave and go back and start over again. Those all sound like factors that are valid considerations for not just temporary alimony, but alimony that's permanent and perhaps at a higher rate than the temporary alimony that was awarded pendente lite. And I guess it appears to me that the trial judge sort of said, we did 2,500 before, let's do it again, and now let's move on to other things. Now, maybe that's an oversimplification, but as I read the order, I don't see a lot of support for that figure or that duration. being continued in light of the uncertainty of Ms. Jane's future?
Your Honor, I think that the uncertainty may have been raised in the appellant's brief, but in fact, the judge made a finding that they didn't have an extravagant life. She addressed their travel as a couple, and that Dr. Agarwal was totally responsible for the paying for the condominium, and that in terms of her ability, her needs and ability, the judge had the benefit of her financial statement, which decreased her demands from pendente lite to the final hearing. That's number one. Number two, the uncertainty you appreciate is someone who is coming to a country and has to then find work. There are the other factors, her age and her abilities. And in fact, she was well educated by anybody's standards and testified to the court. I would say almost bragged to the court in terms of her competencies and her abilities, and claimed credit for making Dr. Agarwal what he was as a dentist here. And she had done press releases in India prior to the marriage. I mean, she expressed to the court her ability to work and be competent. And so that, and I think that goes to the very heart of why the trial judge has discretion. She's got the ability to assess the witnesses. And what the plaintiff said she did, for example, at the doctor's office, turns out not to be what the other employees saw.
Counsel, I share the chief judge's concern that the 6-month figure feels a bit arbitrary. What do you make of that?
I believe it's not arbitrary when you look at suit being filed in 2019 by the plaintiff who engaged the court. So we're looking at 2019. And as the judge said, there were problems in the marriage that preceded that. So, and the demand that Dr. Agarwal not divorce his wife until she qualified under whatever the parents' understanding was of her ability to stay in the US. So this wasn't in a vacuum of his picking these things. So when you look at, we already had 3 years of her living in the residence rent-free, of her being supplemented in the same amounts. Remember, Dr. Agarwal voluntarily paid after he moved out, and he didn't reduce the amount. So there was this ongoing, here's how they lived, and here's what the expenses were. So that all of her costs were accounted for. And so the $2,050 was indeed the difference. And that was an additional order. And in fact, the apartment hasn't been sold yet. So we're now into year 5 already. Well, 4.5, excuse me, in terms of her staying at the residence and not having that expense. And as the court has pointed out, there was this balancing of the other assets. And on Dr. Agarwal's financial statement that I think is important here, he had to borrow a lot of money to maintain everything and pay the attorney's fees and expert costs as we went along, so that he had huge debt obligations that also burdened him.
I don't know why we're focused so much on his income. It feels like it only comes into whether or not he had the ability to pay, and no one is contesting that.
To me, it goes only to what was reasonable and what was going on in that relationship, so that the judge, from our point of view, maintained what was in place and did not diminish in any way.
And something you just said now sort of made me also have another reason to question the 6-month figure. So the judge seems to think that 6 months would have been plenty of time for the property to be sold, at which point she would get a lump sum of however much her 50% interest is minus the mortgage. If the property has not yet sold, and I think we're what now, 6 months beyond the end of the 6 months, does that suggest that the trial court's 6-month estimation was arbitrary, or that we should remand for kind of further considerations in light of the facts on the ground right now?
I know, Your Honor, because everything else has been maintained. And in fact, in terms of the judge's conclusions, it was that that the plaintiff then again had the ability to look for work. Her education has not diminished. So she had all those skills and talents. COVID has opened up, and she had, again, this is only part of it, but she made not any financial contribution to any of the assets that were accumulated.
Well, you're not including the business dental practice in that statement.
No,
right?
because the court gave her the 15% interest, which we thought was overly generous, but here we are. She also, and she's been paid all those monies as well. So she hasn't been diminished by she's received all that the judge ordered up to now. So if you look at that, she received well over, and it'll come to certainly well over $500,000.
And so just to make sure I'm understanding, you're saying that he's still paying the mortgage and she's still able to live there until it's sold?
Yes.
But did the alimony payment stop?
No, he did stop the alimony payment, but he made all of the other payments that were ordered. So she's gotten the lump sum of the interest in the business. We transferred the retirement. She got half, everything that was on the joint statement that is at A74. She has received her share as the court ordered it. So that again, I think that speaks to, I believe, Judge Rigsby, your concern as well in terms of why not extend it. And I really do think it also at the time was certainly a credibility issue in terms of the witness's testimony. And also counsel's talking about how the doctor spoke out of both sides of his mouth with regard to the plaintiff's resume. She and her family went to his practice and certainly caused quite an uproar that the court saw on a video and commented on in her findings of fact. So she had no interest.
There were, it appeared in the 3-day trial proceeding to be a pretty contentious, and protracted set of hearings. And some sharp statements made by the judge in her order. Not necessarily for us to revisit here, but it doesn't change my view of the question about whether it was. I'm not sure. I'm seeing in the record support for some of the statements that the trial judge made about the ability of Ms. Jane to find work and to get resettled and maintained, which is the purpose of alimony, at the level that she was accustomed to during the marriage.
If I may answer that in two ways, Your Honor. The first is that the plaintiff certainly never testified to what her ongoing expenses would be, and provided no testimony about I'll have to travel to India. I'll have to do. So the court had no information about what would be necessary. In addition to, as I say, her extensive resume, and throughout her testimony, her own testimony, and every one of the documents that's in evidence from the plaintiff with regard to her employment history and her efforts were all generated by the plaintiff. Defendant did nothing in terms of what she held herself out to be able to do. So,
except apparently to say that he would not, he would refute it if any employers.
when asked, when asked about had she done what she said she had done in that resume, but there's some distinction about when he saw that versus when she put it out. So it wasn't as if the two of them combined or agreed at any time, this is what she would say. And in fact, she didn't do it. If she had done it, that would be different. Thank you. Thank you for your time.
Thank you, counsel.
Thank you for giving me a few minutes. First of all, in Rock Creek Park versus, let me get that site for you. I cited in the brief, Rock Creek Park Plaza Woodner LTD Partnership versus District of Columbia. The court says that when an expert's testimony may not be arbitrarily disregarded, disbelieved, or rejected, when the trial court rejects the testimony of one party's expert, there must be some basis in the record to support the conclusion that the evidence of that expert is unworthy of belief and that the other expert is worthy of belief. In the brief on page, my brief on page, in my brief, let me just put it that way, I cite the court talking about Mr. Nelson, their expert, at length about his analysis, the reason why he did this, the reason why he went to the 10% discount for lack of control and markability and all those things. The only thing the court said about Mr. Pennington, our expert, was, and this is on the decision on page 26 on the decision, Mr. Pennington did not agree that Mr. Nelson's opinion was reasonable, and he gave no weight to lack of control and minimal weight to lack of markability. I can't argue with that. How do you argue with that? You can't argue with that because you don't know why she does that and what was going on. In terms of one thing to remember, and in a closing argument, I mentioned it, and the court said, are you asking for a rule on witness? Dr. Agarwal had a partner this entire time. From the beginning of the practice on, Dr. Eddy. Dr. Eddy was listed as a witness. You would have expected, and this is what I argued in closing, you would have expected that his testimony, Dr. Agarwal's testimony about the business and her contributions to the business and what he did and what Dr. Eddy did would have been corroborated by Dr. Eddy. Dr. Eddy was never called as a witness. No explanation. Dr. Sider, his wife, was also with him and involved in the practice and building the practice. She was listed as a witness. She was never called. I pointed this out to the court in closing argument. The court mentioned something about, are you asking for a witness? I forget the technical name. And I said, yes, never saw that again. The court, the 8 projects, Your Honor asked about, the contributions. I spent a lot of time saying, here are the 8 projects that happened throughout the entire marriage. They consumed the marriage. Every one of those and everything that she did in those projects allowed Dr. Agarwal to continue working in his practice. And it all had to do with the family. And I said that's extensive information about a contribution, non-financial contribution to the marriage. The employment, I think the resume, I don't need to deal with the resume anymore. There's a couple of other points.
Do you dispute that she has the ability to work?
She has the ability in the context of, is she qualified to work? Yes. Does she have the ability to work, to get a job, if that's to get a job? Yes, if she can find an employer who will apply for an H-1, I don't know if you're familiar with H-1B visas, but the requirement for employers to hire someone who is not a citizen is pretty substantial because they have to show that this is a This person is a special need. They have a special need for this person in their business. And they have to pay for it, cost the aunt around $9,000, that's in the record. They have to also show their documents, their income, and they have to show that they're going to pay her consistent with what they would have paid a US citizen. So it's a very substantial standard for an employer to meet. I don't know the numbers of how many H-1B visas are out there. I don't know, during COVID, I'm sure it was very difficult. And I'm sure in the immigration, as the expert testified to, everything was slowed down in that during that time.
And I know this is outside of the record, but the court seemed to think that she would lose her ability to live in this country once the divorce was finalized. Is that the case? Is she still here?
She's still here. She's here. She's actually here with her parents. She's the expert. The court also recognized that there were several exceptions to that the expert testified to. By the way, they had an immigration expert also that was identified that they had paid for, that had presented a statement, but never testified, wasn't called to testify. As far as the sufficiency of the alimony, the court actually found that for 2019 to 2021, she lived off of loans from her parents and other people and credit cards and accumulated the debt of $117,000. She lived off of this. This was at a time period when he was paying $2,050 a month. She lived off of this. So she incurred additional expenses of $4,875 a month during that time period in order to live, and she incurred them all by debt, which the court told her she now had to pay. So that goes to the question, I think, Your Honor, of one of the problems with the alimony is the sufficiency. It's just not, and the court knew it. The court had the numbers there. I think the court, I don't know why the court just said, I'm going to do peine d'élite, but that's all they said. The co-op is being sold. There is a closing on May 5th. And so she'll have to move out. She'll have to find a residence. She has no alimony. She at this point has no job, except maybe some part-time jobs. She will have to find a residence to move into to stay in this country. And quite honestly, she's been here since 2011. She's been around, she's done a lot of things, if you look at the record, including getting MBAs, including making friendships, including sending out applications, including, getting to know people. And in Milwaukee, she clearly was very sociable and very outgoing. And she created a lot of relationships with him in Milwaukee and throughout the marriage. So I don't know what she's going to do. That's not really a part for this court to consider. I think there is one question that I would suggest that may need to be considered in family law, which is you can have alimony decisions that are term limited, X number of years, or that are indefinite. But to base it on when a co-op is sold gives you no time period whatsoever. It's not even indefinite, because indefinite is a time period, because then that you at some point you can look to have it reviewed, but there's no certainty with when a co-op is sold.
I take that point, but you also, I think, had a pretty arbitrary figure. Didn't you say alimony temporarily for 3 to 4 years?
For 4 years, yes. I wasn't saying, I did not include the co-op in that. I wanted $7,500 a month for 4 years.
And what was the basis of 4 years?
The length of the marriage.
So it's no more arbitrary than 6 months.
There's a formula we tend to use about like 1/2 of the years of the marriage.
All right, Mr. Smaller, we've been very generous with your time today. Thank you for your argument today, and thank Ms. Fogel for your argument. We thank both parties for your briefs, and the case is submitted. Thank you.
Thank you.
All right. This honorable court is now adjourned.